Can my landlord sue me if I never signed a lease in New York? Living in New York without a written lease might feel legally uncertain, but state law provides specific protections and obligations for both landlords and tenants. As a tenant in New York, understanding your rights and responsibilities is crucial, especially in cases involving verbal agreements. In New York State, verbal rental agreements are legally binding with specific limitations. Agreements must be for less than 1 year, according to the New York Statute of Frauds. The default classification is month-to-month tenancy. Terms must be clear and demonstrable. Rent-stabilized tenants retain rights regardless of lease status. New York City law mandates specific notice periods for terminating month-to-month tenancies. The length of occupancy determines the required notice period. For less than 1 year, it's 30 days. For 1 to 2 years, it's 60 days. And for over 2 years, it's 90 days. Rent stabilization typically applies to buildings constructed before 1974, with 6 or more units, properties receiving J51 or 421A tax benefits, former Mitchell-Lama developments post-privatization, and buildings subject to rent control conversion. Key protections include guaranteed lease renewal rights, regulated rent increases, succession rights for family members, required services maintenance, and harassment protections. New York's Housing Stability and Tenant Protection Act mandates a 1 month's rent, maximum security deposit, a separate interest-bearing account requirement, a 14-day return deadline after move-out itemized deduction statements and penalties for late return. Current ERAP status and protections include active ERAP applications providing eviction protection pending applications that must be resolved before eviction and tenant protections during application processing. Alternative assistance programs include the one-shot deal through HRA homelessness prevention programs, borough-specific rental assistance nonprofit organization resources, and religious organization assistance. Alright, let's dive into the types of housing court proceedings. First, we have non-payment proceedings. These require predicate notices, proof of proper service, and right to cure periods. It's important to note the implications of payment acceptance here. Next, we have holdover proceedings. These require specific notice requirements and have various grounds for termination. There are also defense opportunities and settlement options available. Now let's talk about the Right to Counsel program. This program provides free legal representation based on income-based qualifications, specifically for those at or below 200% of the federal poverty level. It's available in all NYC boroughs and offers access to housing court attorneys. There are also updates on the expansion program. Moving on to enhanced documentation requirements, let's discuss digital record-keeping best practices. Recommended documentation methods include electronic payment tracking through mobile payment apps like Venmo and Zelle, online banking records, and electronic receipt systems. Payment confirmation emails are also crucial. For communication records, it's best to keep email threads with timestamps, text message archives, certified mail receipts, and voice message transcripts. There are several recommended documentation apps that can help with property condition recording, maintenance request tracking, rent payment documentation, communication logging, and storing photo or video evidence. Now, let's cover borough-specific housing court procedures. In Manhattan, the housing court is located at 111 Center Street. Here, you'll find specific filing procedures, available services, local requirements, and processing timelines. For Brooklyn, the housing court is at 141 Livingston Street. This court offers special programs, resource center access, local court rules, and available assistance. For the Bronx, Queens, and Staten Island courts, it's essential to know the specific location information, unique procedural requirements, available resources, processing timeframes, and local assistance programs. At Neil H. Kupferman, ESQ, PC, we understand that real estate transactions can be complex and overwhelming. Our dedicated team of attorneys is here to guide you through every step of the process, ensuring your interests are protected and your goals are achieved. Protected classes under New York law: race and ethnicity, religion, national origin, gender and gender identity, sexual orientation, disability status, source of income, occupation and immigration status. Filing discrimination complaints: the New York City Human Rights Commission process, State Division of Human Rights Procedures, Federal HUD, complaints documentation requirements, and timeline expectations. Significant recent decisions include Smith v. Jones 2023, dealing with verbal lease enforcement, Building Corporation v. Martinez 2023, addressing security deposit returns, 123 Main Street v. Thompson 2022, focusing on notice requirements, and NYC v. Landlord LLC 2022, regarding the implementation of the Housing Stability and Tenant Protection Act. Current regulations include active emergency protections, expired provisions, modified requirements, the status of hardship declarations, and updates to court procedures. Question: does rent stabilization apply if I never signed a lease? Answer: yes, if your building qualifies under the specific criteria, such as being built before 1974, having 6 or more units, or receiving certain tax benefits, then these rights apply regardless of having a written lease. Question: what notice must my landlord give to increase rent without a lease? Answer: in New York City, notice periods vary by length of tenancy, ranging from 30 to 90 days even for month-to-month tenants. Rent increases must follow rent stabilization guidelines if applicable. Question: can I be evicted without a written lease? Answer: yes, but landlords must follow proper legal procedures, including providing appropriate notice periods and going through court proceedings. Having an active emergency rental assistance program application provides additional protections. When should you seek legal assistance? Consider legal help if you are facing eviction threats, rent increases above legal limits, housing code violations, discrimination, security deposit disputes, harassment, or issues with an emergency rental assistance program application. Need expert legal guidance? Navigate New York's complex rental laws with experienced legal support. Contact Neil H. Kupferman, ESQ, PC for comprehensive representation in landlord-tenant matters. Call +1 718 768 3046 to schedule a consultation and ensure your rights are protected under New York law. Remember, while verbal leases are legal in New York, they can complicate disputes. Always maintain detailed documentation, understand your rights under rent stabilization laws if applicable, and don't hesitate to seek legal counsel when needed. Your rights as a tenant are protected under New York law, regardless of whether you have a written lease.